and welcome. My name is Chris Markel, President of the General Contractors Association of Ottawa. We are happy to sponsor this morning's session, Construction Law Update, with Dan Leduc from Soloway Wright and Andrew Ferguson from NBC Law.
That's it?
That's it.
Oh, is that enough? Can I tell us a story?
They're great fellas.
That was scripted. So I'll get started. We had a problem. We were given this topic, update to construction law, and it's so freaking exciting, we didn't know where to start, okay? So to help make it a little bit of exciting, we've decided to use the Jeopardy model, and I'll take you through that model in a few minutes. Just an extended introduction, I sit on the board of the Ottawa Construction Association, so welcome. Thank you for attending this. Andrew, a little short intro for yourself.
Yeah,
he and I have files against each other, so we're being polite today, but after hours, I can't stand his freaking guts.
Yeah, no one can understand how lawyers work, because on the one hand, like, Dan and I will just go at each other's throats, and then we'll do something like this, or go have a drink together and pretend it never happened. So it's tons of fun and a little bit awkward. Yeah, my name's Andrew Ferguson. I'm a partner with NBC Law. I do not sit on the board of directors of the OCA. I did sit on the board of directors and was the past president of the local law association. I know Hubie's here, and Hubie was the past chair of the OCA, so I understand how much work that is. So congratulations, Hubie, for being on your way out, because I know I'm on my way out of that, and it's way easier without a part-time job. So yeah, we're going to get going with this.
Okay.
Go ahead, Dan.
So are there Leafs fans in the room? Put your hand up.
It's okay. Put your hands up. Don't be afraid.
We have to figure out how slow we have to talk.
That's it?
There's pictures. No, a little bit more serious. We need to do a toolbox talk. So the Leafs fans, put up your hands again. On our toolbox talk, we have to worry about trigger words. So in this presentation, you may hear words like numerous, consecutive, first, round, playoff, and losses. We just want to make sure you're not triggered. Okay, as a
I already am.
Okay. So yes, we've done Jeopardy. We've set this up. That's me with the Alex Trebek mustache, Andrew with his. And then we did a composite of John DeVries and Alex Trebek, which turned out pretty good, actually, down in the bottom corner. The topic is not exciting. So we're going to speak to you about changes to the Construction Act. We're going to keep some questions at the end. But if you have a question during, just put up your hand. This is a very informal session. And we're going to ask you to choose the monetary value under the topic, but if you do choose, so I'll just point to you and you call it the number, but preferably if you pick it in the dollar value, it'll make more sense as we go through this. Do you understand what I'm getting at? Okay.
Just one more comment. We're here again talking about changes to the Construction Act. I think this is probably our 7th consecutive year coming to these things and talking about changes to the Construction Act. It's been nonstop since 2017. I think was the first round.
Yeah.
So we might have to give some context as we're going through some of this. So, and if you want us to back up and give you some context, we can.
So bear with us as we get through the slide presentation, okay?
This is Jeopardy!
Some of you seem pissed off with that, so we'll keep it a little bit shorter next round. So to get started,
First round, the Jeopardy round.
So the topics we're going to address in Jeopardy are holdback changes, adjudication, proper invoices, price definition, design services liens. Do we have any engineers or architects in the room? Oh, that's too bad. And potpourri at the end, okay? So, Tony. Pick a topic and a monetary value, please.
Proper invoices for 200.
Proper invoices for 200. So, proper invoice requirements. The old rule, the date of the proper invoice and the period during which the services or materials were supplied. The new rule, the date of the invoice and the period, milestone, or other contractual payment entitlement to which the invoice relates. So the impact this creates more specificity of how you must define when services were provided. So a small change in that when you're identifying your proper invoice now and it's tied to a milestone, you're allowed to use that. Okay, so just a bit of a clarification. again, these are not awfully exciting, but I think they're important because what we saw when we first started dealing with the changes to the Construction Act, there was lots of toing and froing at the beginning with the first proper invoice, and these issues would arise.
Yeah, there's not much to add to this one, or you've already gone to the next one, Dan.
Oh, did it already go?
But yet,
Sorry.
we're getting ahead of
Yeah.
ourselves. Yeah, if everyone remembers what a proper invoice is, there's certain requirements that have to be on that invoice to trigger it. That's what triggers prompt payment.
First round, the Jeopardy round.
Adjudication. Thanks, Alex. So that's a fairly small change, and what you're going to see in these, there's some fairly small ones, and there's some that seem small that are actually quite big. And as if things weren't complicated enough, they've just got a whole lot more complicated.
Yeah, my advice to clients, general contracting clients and subcontractors too, would be at the kickoff meeting, do up a mock-up invoice so that everybody's on the same page as to what the proper invoice should look like. And, you know, if as a contractor you supply that to the owner and the consultants and they don't respond, well, at least you tried. But try to get agreement at the get-go as to what the proper invoice is going to look like, okay? You pick the next topic in monetary value. Proper invoice 400.
Oh, we're doing this like the old
Yeah.
school way, right? Like, you know, they used to go in order, but if you watch Jeopardy now, it's chaos. They're all over the place. No
wanna
Jeopardy
take this?
fans here, right?
Do you want to take this one or?
Sure. Okay, so this is similar to the other one. The old rule was that one of the requirements was information identifying the authority, whether in the contract or otherwise, under which the services or materials were supplied. The new rule, you can see the underlined changes there, is that which the services or materials were supplied, such as a contract number, contract line item number, or purchase order number. So this is similar to the other one in that it sort of expands what you're able to do to list out what the authority upon which you're rendering your invoice. So what is, you know, do you have a PO number? Do you have a City of Ottawa contract number or something like that? Like that should be, if you can, specified on the proper invoice to be clear as to, you know, especially in the event if you've got several contracts with the same party, to specify which one you're invoicing under. Very similar to the last change.
Yeah. Peter, pick one. Wow.
Way to go.
So you had the old rule, which had the 5 items that were mandatory for a proper invoice, and it had the catch-all at the end, 6, whatever could be prescribed or, you know, spoken to by the owner in the contract documents. The new rule includes now any other information that is necessary for the proper functioning of the owner's accounts payable system that the owner reasonably requests. So again, we're just tweaking the proper invoice system. So if there's anything added, it should be in the contract, okay? It should be in the tender documents actually as whatever supplementary condition they want to have. That defines what's required for the proper invoice. But if there's some kind of internal thing that the City of Ottawa needs now, that should be and can be included in the proper invoice to give it a better tagging system. So at the outset, we saw all kinds of issues at the beginning of a project with what was supposed to be in the proper invoice and it wasn't. If you misspelled a person's name, oh, it's rejected. It'd be another 2 weeks added to the billing cycle and so on. So we're trying to avoid all that with some of these changes.
Well,
and this is another one.
And we'll see how much this changes it or more confuses things, because there's a word in there that's really, really sort of gray, right? Reasonably. What does reasonably request? Well, I have no idea. Like if you require EFT information or something like that on your invoice, okay, well, that's reasonable. But I don't know, your dog's name or something on the invoice, a little bit unreasonable, right? So like where does that line lie for the owner to say, this is what I reasonably require, and for a court or an adjudicator to say, yes, that's fine, as opposed to something that's way in left field and unreasonable? Who knows what that could be?
Yeah, and to give that context, if you're doing business with the U.S. federal government and their proper invoice regime has 22 items that have to be included in a proper invoice. So we're not there yet, but we're adding, obviously. We're piling on with these kinds of changes. Let's go, I'm going to pick one, proper invoice for 800.
This is getting wild.
Yeah. If it'll work, there we go. Do you want to do this one? Because
Sure.
this one's important.
This is one of the big ones. So under the old rules, you'd submit a proper invoice and an owner could challenge it for a whole host of reasons and that it was not proper. So you get to the 28 days when the invoice is due, and then the owner says, well, actually, no, you didn't technically comply with all the requirements of a proper invoice, therefore it's not a proper invoice. Now the change is, once you submit an invoice, it's presumed to be proper unless the owner objects to it within 7 days. So if you send an invoice that is lacking of what a proper invoice is, let's say it does not have the authority upon which you're invoicing for, which we just looked at, if it doesn't have that and the owner says nothing about it and 7 days pass, it's deemed to be a proper invoice. So now the owner is accepting what it is, and so it's reversing the onus now back to the owner to say, look, if you don't like it, speak up now. Don't wait until the end and okay, I've got my proper invoice on day one. Well, I know it's not proper. I'm just going to hang on to this for 28 days, and when the contractor comes to me for payment, I can just say, well, you know, technically you're not proper, so the 28 days hasn't really started yet, and we're not going to follow the prompt payment rules. Now, the onus is flipped back on the owner to say, now, if you don't like it, or if you think there's something missing, speak up or forever hold your peace.
Yes, John?
Does that flow down?
Well, there's only one proper invoice in a payment stream, and that's from the contractor to the owner. The only jurisdiction in Canada that has a proper invoice applying to subs is in Manitoba. So, yeah, it only has the one proper invoice, and this will only apply to the one going from the contractor to the owner. What we did see in some adjudications that I was involved, especially with municipalities, like the city of Windsor was renowned for this, you would sue on a proper invoice, and they would say, well, it's not a proper invoice. But you didn't give your notice of non-payment. Yeah, but it didn't get triggered because it wasn't a proper invoice. It's to avoid that whole argument that, you know, they could just sit there on your invoice and say it's not proper. You go to trigger an adjudication and say, well, it wasn't a proper invoice, it was missing this and this, you know, 40 days after it's been transmitted upstream, so.
Yeah, we had plenty of battles and disagreements and fights over this issue about the technical compliance with, was it technically a proper invoice, and then did you technically provide a notice of non-payment, and all that sort of argument, and we've all had files where we were dealing with that, and now this gets rid of that, because it's a bit of a procedural sideshow, really, and it didn't really accomplish much. It was fun for us as lawyers to have these weird legal arguments, but at the end of the day, it didn't really help much, I don't think, so this really is going to flip things and speed up the process and get rid of that sort of what I call the sideshow.
So you see your workload decreasing because of something like that?
Yeah, I doubt it.
Not as long as engineers are involved with the process, I'll be busy.
How about design services lien for 200 then?
You want to take that one? Oh. It's always looking for something. So this allows the definition of improvement. So let's go back in time. Back in 1994, there was an actual express provision under the then Construction Lien Act that said architects had no lien rights. It actually said that. So you got into issues where an engineer might register a lien and would want the owner's holdback to pay out that lien. And if you're on for an owner, you would say, well, there's no holdback because the contract that I have with the architect doesn't give rights to, there's no lien rights, so there's no holdback. So then in 95, they took that provision out. Architects and engineers were allowed to lien. Ever since then, we've been trying to define engineering services or architectural services and the Lien Act. And it's always been a mismatch. This allows you to better define what that work encompasses if you have to register a lien or trigger an adjudication. Remember, if you don't have lien rights, you can't trigger an adjudication, you're not entitled to prompt payment and so on. So I think this opens the door a little bit more to allow consultant services, architects and so on, the permissibility of having lien rights, which means you'll have prompt payment, which means you'll have adjudication available to you, and ultimately if you have to register a lien, it'll be available to you, okay?
Yeah, and I think what this does, like what this specific change does is talks about what an improvement is. So we all think sort of an improvement as well as some sort of enhancement or some sort of like, you know, you're improving the land. Improvement under the Construction Act is a more broad term, and I think this is just expanding that even more to say, you know, you can quote unquote improve a project if you're providing engineering or architectural services, even if a project doesn't proceed.
Let's finish up proper invoices for 1,000. You want to do this one, Andrew? This is the 28-day payment clock starts.
Oh, you've got you now. You passed
Oh,
it.
oh,
Come on, Alex.
this is terrible. I can't get that one back. Okay, let's move on. Design services, 400. I don't know what's going on my screen. Lien rights granted if no physical construction. So here again, for the design professionals, even if you do the design for a project that the shovel doesn't hit the ground, you're still going to have lien rights if your work is associated specifically to that project. So if you're doing a general survey of a general area as consultant services, your lien rights can't be tied back to a piece of land, ultimately, for that project. But if you can tie that work back, even if there's no project that comes out of the ground, then you will have lien rights. Again, a further expansion of consultants' ability to get their feet inside the Construction Act, allowing you prompt payment, adjudication, and lien rights.
And then the one thing when I was reviewing this yesterday, which it's not up on the screen, but I remember I said the word reasonable earlier, and like, how do you interpret that? So this section actually goes on, and it says, okay, you have lien rights unless the owner proves that the owner's interest in the land has not been enhanced. So you can provide architectural services, maybe the project doesn't go ahead. Can the owner then establish that, well, those services didn't enhance the value of the land? I don't know. It would sort of fly in the face as to what they're trying to accomplish here. So I have no idea upon which an owner could try to say that and try to establish, well, yeah, I paid $100,000 for design services, but it didn't help me much. I don't know. I don't know how that is going to play out.
Yeah,
It'd be interesting. Like, I don't get it.
And if it's delayed, if the project's delayed because of interest rates going up or so on, how does that play into the owner saying, well, it didn't enhance the value of the land? You actually...
But it did.
Yeah,
Like
you
the whole point of these changes is that it's a recognition now that these types of services do enhance the value. So now to turn around and say, well, actually, if you prove it doesn't, then you don't have lien rights, I don't know.
Yeah.
I guess that'll be a topic for next year.
It's
They'll probably identify what the need.
There'll be another change? Is that what you're going to say? Yeah.
or Dan or I will get more work to fill in for the other work.
Let's go with design services for 600. Again, this is tied to that. The whole notion is that your services have to be tied to a specific identifiable piece of land. And as we call it in Ontario, property, you need to be tied to a PIN, a property identification number. So the examples here, if you're doing conceptual kind of drawings as part of a design build or something like that, and you're not paid, but it's not tied to a specific property. So if the City of Ottawa has some kind of open contest for design services for some kind of project, they don't know where they're going to put it, you won't have lien rights because you can't tie it to that piece of land. So it's got to track back to that land.
And this is no different than lien rights generally anyway. Even for any supply of services or materials, you have to be putting it on a specific piece of land. You can't, manufacture something, leave it, hasn't taken delivery yet. You haven't put it on the land yet. Similar to this, if your design services are attributed to that land, they're lienable. If they're not attributed to a specific parcel, then they're not, which is, it just evens it and makes it clear for all lien rights that you need to specifically attribute to a piece of property.
Yeah, it becomes a little bit trickier if you're a supplier and somebody comes in and takes whatever, shingles, but it's not tagged to a project. If you can trace the supply of those shingles as a supplier to the project, then you'll have lien rights, even though it wasn't tagged on your PO, for example. But the effort to try to find where your shingles are being used can be a little bit difficult. But again, if you can trace your services or products to a specific piece of land, then your lien rights will accrue, be available to you. Design services, 800. Oh, this one will make the engineers happy. So they haven't announced when the Construction Act changes are going to come in, but when they do come in, because we had a provincial election that kind of slowed things down, when they do come in, your design services will be retroactive. So the new changes, most of the changes only will start from when it's pronounced as law, but for design services, and the example up there is if you did design services in 2024, and the project is only going to take place in 2025 or 2026, your lien rights and your availability for prompt payment adjudication will be extended into that. So it's kind of a grandfathering provision for design services. Okay, so it's a little bit more of again, widening the scope and availability for architects, engineers, and other consultants to have lien rights and construction rights like prompt payment and adjudication.
Yeah, and I think that's just recognizing that there's no reason why design consultants shouldn't be treated the same as other typical lien claimants. And so this is just sort of bringing it back further and saying, well, we mean it to sort of, in a way, exist prior to these changes, which is more fair.
Yeah, and you got to remember, there's going to be two separate, for every contractual chain that comes out of the owner, there's going to be a separate holdback available. So if you have an owner contracting with an architect, contracting with a series of sub-consultants, that has its own separate holdback, separate and apart from the actual construction holdback. So your lien over here, if I'm an engineer registers a lien and the electrical sub registers a lien, they're liening the same parcel of land, but it's two separate holdback funds that they're attaching to. So it's the same, but it's different in a lot of respects. So you'll get to court and you'll be arguing on the same project that you did electrical engineering services and the electrical sub's not paid, but you got two different claims effectively.
And one of the things that's going to be a little more challenging to try to sort out is when you have sort of basic lien laws, you have your 60 days to lien, but if you're contracting with the owner, you have 60 days from when you've sort of finished providing the services. Well, if you're a design consultant, when do you finish the services? Like, is it when you've produced the drawings? Is it when you've produced the specs? Like, or are you still going and are you still making changes? And it's going to, how long then does a design consultant have to lien? Seems like you're going to have a long time, but how do you pin a time in when that contract, the design contract with the owner, when did that come to an end? And that's going to be harder to pin. Supplying of services, you have a timesheet or delivery slip or something like that. That's really evidence as the last supply. Design consultant might have internal timesheets, docketing sheets or something like, which might show the last time they worked on a project, but when was it done? And you might see design consultants, you might see those lien rights run for a long period of time, and you might be liening when you may not have done much work on the project for several months. You might still have your lien rights still existing.
Yeah, there's no certificate of substantial performance on the architect or consultant's payment stream, as an example. We're going to run out of time here if we don't pick it up, unfortunately. So let's go to holdback changes 200. So this is more clarification because we had the availability to have holdback released on an annual basis under the old act if the contract mandated it. So there was that condition that your contract had to say that we will release holdback every 12 months from the anniversary of the project. This now says for every project, you're going to have mandatory release of holdback every 12 months. Okay, simple as that. They've just taken out that condition that the contract has to have it. It's now mandatory in every project. Again, the whole idea is to assist with cash flow. You're in the worst paid industry in Canada by far. So I had the opportunity to be in council of Prompt Payment Ontario, which was the Ontario caucus of the National Trade Contractors Coalition when these changes were coming in the first time. And I got to see all the polling that we did, the actuarial reports and so on. Your industry was the worst by far. You were happy to get paid on 70 to 90 to 120-day terms, whereas even retail was getting paid on 40-day terms. So again, this is all to push money through, get your holdback done on a project that's going to last more than a year, get that holdback released. Now, it also triggers lien rights and other considerations that you have to worry about associated with that.
Yeah, and I think out of all the changes, that's to me that's the biggest one, is this annual release of holdback. This is more administration on everyone's part. It's more forms, more publication, because at the end of that 1 year period, there's probably going to be a form, I'm assuming, that's going to be published. Yep. Yeah. So there used to be there used to be 18 forms. Now there's like into the 30s of all these forms, and so now all these things are getting published. Everyone's going to have to be watching, hey, is this a project that's gone on 1 year, which may be difficult for a subtrade to know because you don't necessarily know when the prime contract's been going. And everyone's going to be watching, okay, am I at a year? Has a CSP been published? And do I have to lien for my holdback? Because if you don't lien for your holdback within the 60 days after that, I guess, publication of annual release of holdback, I guess it's going to be called. Form, one of these things. So once that's done, you're thinking, okay, well, how's the project going? And should I be leaning for my holdback, a year into the project? Because if I don't, my lien rights for my holdback are out the window, and I can't lien for them later on down the road.
Exactly. Let's see if this works here. There we
It's
go.
just more work for all of you, right? That's all this is. And as if this stuff wasn't complicated before, now it's getting even more complicated administration-wise, right? How do you administer all this?
It's to help with cash flow. I thought it was to help with cash flow, but
It's great for sure.
it's the government. There's more forms.
Yes, cash flow, great in theory, yes. And this is designed also to help those who are the first on the project, right? If you're form work or excavation, and this is a 3-year project, well,
Yeah.
you're not getting your holdback for 3 or 4 years. Like, that's always been a huge problem with all of this, and that's now geared to solving that as well, which is good.
Yeah. So this one here, this one bothers me because we've lost the concept of what holdback is. So you got to remember, holdback is an amount, it's an accrual, okay? It's a notional account of 10% of the money that's been certified and hopefully paid, okay? And that's all it is. And it becomes a notional account up until the lien rates expire. And then it just becomes contract monies owing, okay? So it has no intended purpose other than to remain as some kind of conditional account in case liens arise. It is not performance security. It's not a deficiency holdback, okay? And we see that a lot where it's used and they leverage the holdback. Well, you got this punch list of 300 items that you got to do before I release the holdback. That's gone with these changes when they come in, okay? So this expressly says, you know, the repeal of the owner's right to withhold holdback for set-off or deficiencies is gone. So that holdback becomes really unconditionally, it should be paid 60 days after the publication date of a CSP or your last day of work, whichever's earlier. How are we doing on time?
Yeah, we gotta speed it up a bit.
Okay, let's stick with holdback. Again, this is tied to that, so this is a mandatory release of holdback now. There's no more, prior to the changes in 2018, it said the owner may release holdback after the liens expire, and then we changed the wording to shall, and that still wasn't working, okay? So now it's even more mandatory now, okay? Must release the
And then
holdback.
we'll see about whether making it more mandatory actually helps,
Well, yeah,
to be seen.
it'll help you with an adjudication, I guess. It gives you a little bit more leverage that way. And this is what Andrew was talking about. There's going to be published notices associated with the release of holdback, so the owner has the obligation now to publish these, preferably in link to build. John, is that right? Yes, yeah. And not in Daily Commercial News? Is that the one we're not supposed to talk about? Okay, or Ontario Construction News. Sorry, I'm on the board, so just so you know, link to build is actually owned and operated by 7 construction associations in Ontario, so the money comes back to the associations, unlike Daily Commercial News, which is owned by an American investment firm. Elbows up, everybody? Okay, good.
But when you are looking for CSPs, there are 3 places to look.
Yeah.
At least for now, until people start to use maybe one certain common one.
And I found a site that will search all 3 concurrently.
I saw that too.
Yeah,
I know, but
okay.
but it says you cannot rely on this for any accuracy, blah, blah, blah. Like,
Damn lawyers. And again, just aligning the holdback payments with prompt payment, just to make sure that, you know, there's no hang-ups here with holdback. It's got to be released in a timely manner. Let's try adjudication, 200. So, you want to speak to this one?
Sure. So adjudication prior to these new changes, the main purpose, or at least the stated purpose of adjudication, was to solve issues on projects as they're going, right? Disputed change order, project still ongoing. You can have that resolved, have that, if money is owing, great, pay it, move on. If it's not owing, too bad, keep going. That was sort of the general sense. We saw that the wording was a little unclear in the adjudication, and so wording, so we as lawyers were doing a lot of adjudications even after the projects were at an end. Now this has clarified that to say, yes, you actually can do it when a contract's at an end, but you have to do it within 90 days. So it sort of gets rid of, you know, the 7 months later, someone trying to trigger an adjudication, which is supposed to be a quick, timely resolution to something, what we call sort of a quick and dirty resolution to something, as opposed to a lengthy matter going on for years. So now they've just clarified that to say, hey, you can do it, but you got to be somewhat quick with it after the contract's done.
Stick with adjudication, 400. So, anyways, I'm not medicated enough to deal with City of Toronto lawyers. Any adjudication I've done with the City of Toronto, or the City of Windsor for that matter, the first thing they say is, well, you're not allowed to adjudicate about this thing. It'd be like, it could be a disputed change order on scope. It could be release of funds. Could be they would automatically just say that and say, well, it doesn't fall into that little box, that tiny box under Section 13, so you can't adjudicate on this issue. And that would start a whole process of jurisdiction. So now your adjudicator has to determine whether he or she has jurisdiction. So you have to make separate submissions on that. So you do your written submissions in response because the City of Windsor is challenging that. So it adds 3 weeks there, okay? And then the adjudicator will make his or her decision in 4 or 5 days. So now we're a month into the process and we still are arguing over whether or not we can be here, okay? And I was seeing that on 90% of my City of Toronto. City of Windsor was renowned for it as well. City of Ottawa, not so much. That's gone now. They've really expanded the scope of what can be adjudicated. So you're going to have much more ability to trigger an adjudication pretty much on any dispute. Now, if you're being back charged as a sub because a Ministry of Labor fine associated with something that you did or did not do, and you want to challenge that back charge by adjudication against the general contractor, that's not available to you, okay? That still falls outside of adjudication. That's an extreme example. But pretty much everything else now is going to be adjudicated and available to you through adjudication.
Yeah, and what they've clarified is that you can do it, you can refer any matter you want. So the parties can agree to say, hey, look, we're going to adjudicate this particular matter. The problem I have with that conceptually is why would I pay to go through ODAC and pay, anyways, I can go on a rant if you want me to. Why would I go through ODAC to go to that process if everyone's agreeing? Because you could just agree to sort of hire a private adjudicator or a private arbitrator, which is probably way more reasonably priced, and do it that way instead. So I understand there's probably some sort of lobbying going on with ODAC or whatever to try to get people through the system, which is an okay system, but there are other ways in which to resolve these if the parties are getting along procedurally to say, hey, look, how do we want to fix this? How do we want to resolve it? Can we do a private adjudication?
How many of you have been through the adjudication process? Okay. That should pick up slowly. We think it should anyways.
It should.
When ODAC started and we had the changes to the Construction Act, the first year, 80% of the adjudications were home renovations. So a dispute, and they could be $30,000, $40,000, $100,000 disputes, but they were seeing home renovations coming through and they're like, this isn't working. We need to open this up a little bit more. So that's part of these changes now, but I think your dispute resolution process for adjudication is going to pick up. And I find, I don't know if you find this, I probably issue a notice of adjudication once every 3 days, and maybe only 20% of them get to a hearing. Like, we resolve things pretty quickly. Like, we'll suspend the adjudication, have settlement discussions. If that's not working out, trigger it again, go through the next step. Oh, let's stop, let's go back and try to resolve it in that process. So
That's very true, and it's a very simple, straightforward way to start one. If you haven't started one, you sign up for an ODAC account, and you go and you basically fill out an online form. So you don't have to provide all your substantiating documents right away. You got to do it pretty quick, within a couple of days, but anyone can go in and start an adjudication. As Dan says, like, sometimes we start these, the email goes out, and then after a couple of days, the matter is resolved. So it is a way to sort of trigger things and push things forward.
So we're going to rush through this a little bit more here. Do you want to do this one?
Sure. So so now the rule is when you do adjudications, if you have separate issues, so let's say you might have issues resulting, you might trigger an adjudication that's got like 3 or 4 change orders or something. Those now need to sort of be separated out effectively it's in one adjudication, but treated separately and distinct. I think that gives more clarity about which ones are being dealt with, which way the adjudicator's leaning on it. But it also makes it cleaner in that it's hard to do 7 adjudications about 7 change orders, different ones with different adjudicators. So you're trying to sort of keep them together because you might have findings of fact that are different from one adjudication to another.
Just to give you a sense of what that means is, I have an adjudication that I started in February. My client does road work in the City of Toronto, 2 streets running parallel to each other, 1 tender process, but 2 separate contracts. So it's the same parties, the same type of work, same consultant, same city officials, but 2 separate contracts. So I started an adjudication on both concurrently. The city said, no, it's 2 separate contracts. You have to have separate adjudications. And it added another 6 weeks to us arguing over that. I was like, oh my God. So that's going to change now. It's going to be a little bit more streamlined, hopefully. Oh, sorry.
What happened to giving every people the choice to pick?
To what?
You're not giving the people the choice to
I
pick.
don't like
You're-
them that much. This one here, I've had better crowds. Seriously,
okay,
honestly,
all
there's
right.
not a lot of applause.
I mean, it's 9 o'clock in the morning.
Well, they've had their coffee. They're construction workers. Their day's half
Yeah, I
over,
suppose.
isn't it? This was a bit of a gray area too. So you'd have some people saying, okay, well, the adjudicator made his or her decision. It's binding on you. The payment obligation is there. You got 10 days to pay and so on. And then they would argue, but the project's over, so that adjudicator loses his or her jurisdiction, so it's not a valid decision anymore. We saw those arguments. We were like, really? So that's been clarified so that the adjudicator's decision is binding. And the only way you can deal with it is through a subsequent arbitration or litigation. And even there, the adjudicator's decision is going to be given, it goes in as evidence. So it's not binding on that judge or that arbitrator, but it's pretty heavy evidence, because if you got somebody who did 40 years of heavy construction and made a determination of the Proctor standard associated with that parking lot, and you drop that in front of a judge who did family law for 30 years, he's going to defer to the adjudicator's experience and so on. So it's going to be given a fair amount of weight.
And the other important thing to note there is when you get an adjudication decision, you can turn it into a court order. And so that court order is enforceable. And if the contract's at an end, one of the big teeth to adjudication is that if the contract's still ongoing, one of the options available to you as a successful trade is you could actually walk off the job, and you're allowed to walk off the job if the order wasn't satisfied. If a contract's done, you kind of can't do that because you're already off. But the order itself remains enforceable. You can still enforce it as a regular judgment. So it does give you still some leverage.
Yeah, to give you an example of that, I've got one now. I had an adjudication decision in December 2023. I'd registered a lien at the same time, won the decision. They didn't pay. They kicked us off the job site as soon as we started the adjudication. Seemed appropriate. Didn't pay. I've got a judgment. We're garnishing their bank account, and I still got a lien in place. So we're getting money against the judgment. So when I get to my lien trial, I'm going to be owed very, very little. It kind of making the lien trial kind of like useless, but it helps with cash flow. Again, we've got this adjudication decision, which going forward has reduced the amount of my lien because we keep getting paid out of it. So it's an amazing tool to take an adjudication win, convert it to a judgment, which is very simple to do. As Andrew said, you just go to the counter and they stamp it. And you've got your decision, which is enforceable through writs of seizure and sale, garnishments, and so on. Last one in adjudication. Yeah, this is just a catch-all that there's still, like the adjudication process is supposed to be 30 days. And I haven't had one that's been 30 days yet, so they're trying to compress that back to where it was. I've had some adjudications that take 6 months because the adjudicator says, well, we're going to get some expert reports on this aspect, that aspect, you need to do revised drawings, bring me the revised drawings, I'll make that decision, and so on. So they're trying to condense that down and make it a little simpler process. For those of you who do get into adjudication and you see the adjudicator's fee of like $800 an hour or $600 an hour, please understand 40% of that goes to ODAC, the company that runs adjudication, so that adjudicator's only getting 60% of that hourly fee ultimately, which is crazy. I'm still shocked that ODAC skims that much.
That was
of it.
part of my rant.
Okay.
But yes, it's insane because you see these hourly rates, you're like $800 an hour. Yeah, but they're getting like half of that, right? And so again, trying to push all this stuff into ODAC, you don't need to go through that process. There is help, there is good stuff about it, but you don't have to do it. You can do it other ways.
And I'm down to about 10 adjudicators that I use.
I think there's very few adjudicators left in the province, it seems.
Yeah.
A lot of people have backed out because it costs a lot of money to actually get your certificate or whatever. And then some of these people are senior lawyers who are doing this, and they're working, at a discounted rate and probably a lot longer, like time-wise, than what they had anticipated. So I think we're running out.
Yep, I think you're right. Let's go to price definition for 200. This was just a simple change. So the definition of price always freaked me out in the old Lien Act and the new Construction Act because it had a weird definition done by legislatures that didn't appreciate what the cost of construction was. So it kind of excluded cost plus contracts. So that's been clarified now. So a cost plus contract, there were some actually people would say with a cost plus contract you had no lien rights because the price wasn't defined. It's like, well, you don't have a defined price, but you're doing construction work. Why wouldn't I have lien rights? So that's been clarified through this change here, that cost plus contracts will be part of the definition of price under the Construction Act. You want to take that one?
I think the same concept for this one here. Price now includes extras, change orders, allowances, et cetera. I mean, I think it would be a silly argument. I think I saw someone trying to make it once to say, well, you can't lien for it because it's a change order, which was silly. So it's kind of, all this is really doing, I think, is clarifying the way everything was anyway, but it just gets rid of the silly arguments sometimes to say, well, you can't lien for something that's extra to your contract, which anyway, never made any sense. So that's now been fixed.
Oh yeah, this one here now, price will include cash allowances, whether or not that cash allowance has been fully used or not. So that was another clarification, because you didn't know whether you could include a cash allowance in your lien, the amount of your lien. So that's been clarified now. So a cash allowance will be permitted to be included in the amount of how you calculate your lien. Simple enough, hopefully. This one here I'll speak to because, man.
You missed it.
So oh, it did? Terrible. I'm going to find a way to blame my son for this. So I lost a case. I don't hear a lot of empathy from the group. Yeah, I lost one. So I was on for a Quebec
I was
design.
opposing counsel.
I was on for a Quebec design builder doing a biomass plant in Oshawa, where my guys barely spoke English. So we had an issue, and there was price overruns like crazy, and we litigated in Oshawa, where the owner said, hey, listen, I hire 150 local people, and the judge who's from Oshawa was like, oh, that's important to me, and so on. I don't sound bitter, do I? Anyways, I registered a lien in 2017 under the old act for $32 million, which was the cost of performing the work for my client. I'd hired Deloitte, who did an audit of our costs, and we had an overrun of $32 million. So I said, that's the price. And I had an expert report, an audit, showing that's what it costs to build this thing. And the judge said, that's nice, but that's not your contract price. And so he cut the lien down to $16 million, okay? Because that was the amount that was related to change orders, unpaid work, and so on. So lots of discussion. That was a case called HMI and Index Mills. Lots of discussion in the legal community about, well, what do we include then? If we got a disputed change order on scope and I actually perform the work, can I include that disputed change order in my lien? And the answer is coming more and more no. Certainly delay damages cannot be included. So my understanding prior to this was if I had lost productivity on a job, I had an overrun of 10,000 hours on the labor side, I can show that that was a cost that I spent on that job for those workers at that project. That can't be included now. If you had a delay claim, extended overhead, I can show you that that site trailer that I carried for 8 months in my bid now took 22 months. That's an overhead, extended bonding cost, all that sort of thing. So they've really defined the line and pulled it back as to what you can and cannot include in a lien. So a lot of those items that are damages now cannot be included in a lien. So we've kind of shifted away from what I perceived you could include in a lien back in 2017 to now where it's really pulled back.
And it's not to say that you're shut out from making the claim. You just can't lien for it, right? A lien's only one remedy under the Construction Act, so it's not the end of the world if you can't lien for it. You can still make the claim. You can still lien for your contract amount owed and then make a claim for all of it, the entire balance.
Yeah. So again, we didn't know what you could and could not include in a lien. So like I said, in 2017, I decided, what the hell? I'm going to throw it all in there and see where this lands. It was pulled back. So now we're kind of matching that case law that came out associated with that to pull back. Let's do, for John, who sits on the board of the OCA with me, and we tease each other extensively. He's an engineer and I'm a lawyer. Again, tied to giving engineers and consultants more lien rights, more rights associated with that, you get prompt payment as well as a consultant. So I don't know who's certifying your draws. I don't know how that works. Like I don't know who's approving the consultant's invoice. I presume it's just the owner. But in any event, you've got prompt payment regime that now applies to design services as well in the province, because there was some discussion that it would not apply. Finally, let's go to potpourri. 200. Oh yeah, so this is, when are these new rules going to come in? We don't know yet. We had a provincial election which kind of held that up. They were pronounced in November of last year. Yeah, November last year. Had third reading. They just haven't been proclaimed yet, largely because of the election. So when they do come in, the only part that gets grandfathered is the engineering services and lien rights consultant services for that. But you could end up, as the example says here, you could end up with a situation where the general contract, the prime contract was made before the changes, and some of the subcontracts were made after the changes. So the provisions, the new provisions will apply to the subcontracts, but not the prime contract. That's going to happen. And I'm like,
Yeah, and one of the big things that they have sort of tweaked with that is the obligation for annual release of holdback. So that doesn't really get grandfathered. So if your contract is, if this comes in July 1st of 2025, your contract starts, prior to that, then the annual release doesn't kick in. So that's also getting sort of grandfathered in, so that you don't have to, maintain that or watch that going backwards.
let's do potpourri for 600. Yeah, you're going to see some, they're not out yet, but you're going to see some changes with adjudication rules. ODAC sets their own rules in a lot of respects, sets their own fees and so on. So that's going to change now. I think it's going to get more expansive and expensive because you're adding different things to the adjudicator's role. So keep an eye out for that. Yeah, those three items that we addressed earlier will be part of that. 800. Oh, I can't say this word. Anonymized. Anonymized. So what happened was adjudicator decisions would come out and there's no public record of them anywhere. So what would happen is I'd have lawyers going, hey, did you see this adjudication decision I just got? And we would start sharing them amongst ourselves. And so I kept, some volume. So I knew exactly what Ted Dreyer, an adjudicator lawyer out of Kitchener, would argue on completion and whether I had that. So when I had an adjudication with Ted, I could just use his argument against him. So we had these decisions and there was no informal way of, they're not binding on anybody. Now they're going to keep a record of them, but it's going to be anonymous. The parties aren't going to be identified. The adjudicator's not going to be identified. It'll just give you some sense as to where the adjudications have been where the decision making is going on a lot of issues. So there's a little bit more aligning because I'm seeing some decisions from adjudicator. I can show you two decisions from two adjudicators on the same issues in different parts of the province, and they're the exact opposite to each other.
Well, and that's the thing. Even publishing these, they're not binding on one another. The only thing that's binding on an adjudication would be a court actually saying, here's what the law is. An adjudicator is saying, here's what I think should happen, or here's my interpretation of this proper invoice, or et cetera. And another adjudicator could look at it and say, well, that kind of makes sense and use the same reasoning, but you don't have to, which is why you can have completely separate decisions or completely opposite decisions. But at least this way, you'll have some sort of resource to go to and say, well, if I try to go down this path on this particular issue, am I going to succeed, or all the adjudication decisions that I can find all go on the other way, in which case, well, I know I probably shouldn't try this.
And I think it's going to help adjudicators themselves have access to what other adjudicators are deciding to give them a little.
Did your battery just die?
I have no idea. It's plugged in.
Yeah. What, do we need it?
No, we don't need it. We only had one left.
I think we're only got one or two left anyway. I don't think there is a Final Jeopardy. If we had time, we wanted to add a Final Jeopardy.
I had music for it too.
Oh.
That's okay.
As Dan gets it back going, I think we only had one or two.
Yeah.
Questions?
Yeah, I just had one additional potpourri item, which was tied to elbows up. So just so you know the history of lien legislation in North America, it's a North American concept. So in my prior life at a prior firm, same firm that Mr. Gallagher and I worked together at, he's at the back of the room, I had construction law partners in Australia, South Africa, England, and you'd say, well, this lien stuff, blah, 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 and they'd be like, what the hell's that? So it's an American concept, but my American partners knew about lien legislation. So what happened was during the War of 1812, when the British/Canadians, we'll throw that in there, decided to burn down most of Washington, including the White House, they couldn't get tradespeople in because they weren't getting paid. So they gave tradespeople the ability to take security in the premises that they were working on, and that was our first lien legislation. So it's tied to the British burning down Washington, which seems really topical. I can't think of anything more elbows up than going down and burning down the White House right now. So that's the history of our lien legislation in Canada. We have it in every jurisdiction across the country except for Quebec. They have a different system there because it's a civil code system. But if you look at the lien legislation, if you look at the lien legislation in, for example, New York, it's very similar to our lien legislation here. Sorry about this, everyone. I have no idea what's going on.
And if anyone questions the veracity of that, Dan did put that slide in, and then I Googled it and read about it, and it actually is true.
Yeah. Oh, it used to be.
And no.
No. We don't work well together.
No, I don't like this guy.
We're fighting each other all the time. Let's just open it up to questions. We have about 10 minutes left for some general questions. Anything about the Construction Act, anything about delayed claims, contract interpretation, we're happy to try to take that, except for that question, sorry. No, it's okay, go ahead.
With the changes to the holdback provisions, do you think that there's absolutely no ability to use it as some kind of performance-related chargeback mechanism? Do you think there could be a return or introduction of contracted in retainage or something additional?
Well, I mean, as it is right now, because that's always been the case, there's no contractual right to withhold holdback. And as Dan said, holdback is not actually money. Everyone thinks it's money. It's a notional value of services, right? And so it's always been treated as money, and contractually, unless there's something in the contract that allows for a deficiency holdback, or a lot of times it's a maintenance holdback of like 2% or something, a lot of times you see that. But any contract does not say, actually is not allowed to say, that holdback can be retained. Because if you try, you could put that contract provision in that says, I'm entitled to withhold the holdback from you for all these reasons. The Construction Act says, you're not allowed to do that. You have to comply with the Construction Act in every contract. So that's the thing. In theory, and for the last couple years, holdback has been mandatory to be paid. It says shall, as opposed to may. And I don't know if that made much of a difference, because practically, what people do is they withhold the holdback to maintain leverage. And now you got to ask the question, are they allowed to do that? And the answer is no. Well, what do? I don't know. Lien for it. Or adjudicate for it.
Yeah, unless your contract explicitly says there's a deficiency holdback and here's how we're calculating it. The notion of deficiency holdback's lost on me as well, because somebody is certifying my draws throughout the whole project. And the certification process means that the work has been performed in general conformance with the plans and specifications. That's what the certification, and certification is a pretty important process with a quantity surveyor certifying a draw and so on. So I get to the end of the job and you give me this punch list or deficiency list that has 300 items on it that go back 6 months. Then, the Irish part of me turns to the consultant and go, did you certify deficient work 6 months ago? Because you paid me for it, but now it's deficient. What's going on? So this whole notion of deficiency holdback is lost on me because of the process that we go through. So unless your contract says, well, we're going to maintain 5% deficiency holdback, then it's a contractual clause, they're doing what they're doing, then I think you may see that. But also, then why do we have a performance bond? Why are you paying for a performance bond? That's security for performance, and if I don't do it, you can hire somebody, you can claim on the bond, and they'll come in and do it. So, I don't foresee that happening. I just think it has to be treated differently. Certainly, holdback, as Andrew said, can't be used as performance security. Yes, sir.
Two questions on a contract I'm working on that dovetail right into what we're talking about. One is the
Yeah.
That's right, a
Just
lot, yeah.
go and look up sections 4 and 5 of the Construction Act. It's right at the beginning. And in fact, every province, the Builders Lien Act in BC has the same thing. So if you want to use that as leverage against them, so they should be familiar with it. But it says right there in sections 4 and 5, you cannot contract out of the rights that you have under the Construction Act. And section 5 says, if you do, it's void, or that portion of it's void. So like Andrew said, every contract for construction in Ontario that's not related to the federal government is bound to the prompt payment terms, the lien rights, the adjudication rights that you have.
Second part of my question is the terms of the contract, they certify their own, they don't really use the consultants the way that we typically do, and they certify payments directly as the general contractor that also acts as the owner.
Sorry.
So they're
Yeah.
two different entities, there's one company.
Yeah. There's a bit of a conflict of interest there, but yeah, go ahead, sorry.
I agree.
Yeah.
But they pay, so it's okay.
For now.
But I read something in the contract that just because we pay you doesn't mean that the work is deemed non-deficient, we'll call it.
Yeah.
Is that,
You see those express terms in some standard form contracts too. It's not a deemed acceptance of the work with payment. Yeah, that's where that deficiency holdback might come in. So, the argument might be, well, yeah, but you paid me for it. How's it deficient? Well, they said, well, we didn't accept it.
yes.
So yeah, that could come back and justify them giving you a deficiency list and taking away your argument that, well, you paid me for it.
Okay, so watch out for that one. What would you guys would counter that as lawyers by striking through, or what would be the happy middle ground on that?
Well, I'd want to hear from my client as to, did you do crappy work? Like, are these deficiencies? Like, every project has deficiencies, so is this beyond? Or did somebody else come in and tear out stuff after you did your work? So you got to get the factual basis for their position before I can give you a legal position for it. I don't know, Andrew, what do you?
Yeah, I mean, if you're talking about trying to renegotiate or reword the contract, you could, or if they're putting provisions in there that fly in the face against the Construction Act, you can say, yeah, I'll sign this, but just so you know, they're not binding anyway. So, and the whole thing about, them certifying their own payment, yeah, technically you can do that, but I think ultimately what would be a conclusion, like you still have to establish the rationale behind it. Like, because I've seen that many times before where owner, developer, contractor certifies their own, but is it really certified? It's not independently certified, so I think it's given very little weight.
I think that's all the time we have, unfortunately. We're around the balance of the day if you want to approach us with your question privately, because you're too embarrassed to share it in front of everybody else, showing how much you knew, so happy to do that.